Good morning, ladies and gentlemen. Welcome back to the series of tutorial and voiceover on mercantile law. We have been covering the topic of industrial relations, and the topic of discussion right now are the trade unions, the Federation of Trade Unions. Having had explained them, defined them, exemplified them, now we talk about the rights and privileges of trade unions. So I've explained that they have got the right of incorporation. They've got the privilege of immunity from criminal suit, and they also have got a right and privilege of immunity from civil suits. Well, in the continuation of my tutorial, I go through the topic. A trade union shall not be liable in any suit or other legal proceedings in any civil court in respect of any tortuous act done in good faith, in contemplation or furtherance of industrial dispute by an agent of trade union, if it is proved that such person acted without knowledge of, or contrary to express instructions given by the executive of the trade union. Enforceability of agreement. An agreement between the members of the trade union shall not be void or voidable by reason only that any of the objects of the agreement is in restraint of the trade. The civil code is not entitled to entertain any legal proceedings for the purpose of enforcing or recovering damages for the breach of any agreement concerning the conditions on which any members of the trades union shall or not shall sell their goods, transact business, work, employ, or be employed. Well, now we talk about the collective bargaining agent. The trade union of workmen is the agent of the workmen in the establishment or industry in the matter of collective bargaining. The CBA is determined as I explain further. One union. Where there is only one registered trade union in establishment of the group of establishment, and its members are not less than one third of the total number of the workmen employed in such an establishment, upon the application of such trade union, the registrar shall certify that trade union is a CBA. Trade union to be the CBA. More unions. Where there are more than one registered trade unions in an establishment or group of establishment, the registrar, upon an application or by any trade union, shall hold a secret ballot within 15 days to determine the CBA. In case of a large establishment having branches in multiple towns, the registrar may hold the secret ballot within 30 days of the application. The registrar shall not entertain the application in case of seasonal factory unless such an application is made during the month in which the number of workmen employed in a year is usually the maximum. Procedure of the election. The procedure for the determination of CBA is as I explained. Notice to the union. On receipt of an application, the registrar shall, by notice in writing, call upon every registered trade union to which application relates to indicate whether it desires to be a contestant in the secret ballot or to be held for the determining of the CBA. If it so desires to submit to him, within the time specified in a notice, a list of its members showing, in respect of each member, his parentage, his age, section or department of the place in which he is employed, ticket number, date of becoming a member. If union is a federation of trade unions, a list of its affiliated trade unions, together with a list of members, along with their particular of each such trade union. List of workers. Every employer shall submit a list of workmen, excluding those whose period of employment is less than 3 months, and showing in respect of each workman his parentage, age, section, or department and place in which he is employed, his ticket number, and the date of employment. Verification. Every employer shall provide facilities to the registrar for the verification of the list submitted by him with the trade union.